Welcome to Oregon, fellow patriots. As new residents, understanding the state's unique approach to firearm ownership is crucial for exercising your Second Amendment rights responsibly. Oregon's gun laws can differ significantly from other states, and it's vital to be well informed to navigate these regulations effectively. Let's begin with the duty to inform law, a common point of confusion for many gun owners. Oregon is proudly a no duty to inform state, meaning you are not legally obligated to tell a law enforcement officer that you are carrying a concealed handgun. However, if you are carrying concealed, you must always have your concealed handgun license, or CHL, readily available. Failure to present your CHL creates a legal presumption that you do not possess a valid license, which can lead to unnecessary complications. Moving on to concealed carry, it is only legal in Oregon with a valid Oregon CHL. To obtain this essential license, you must be at least 21 years old and demonstrate competence with a handgun. This competence can be proven through military service, an approved firearms training course, law enforcement experience, or an NRA-certified course. Oregon operates as a shall-issue state, meaning county sheriffs are generally required to issue a CHL to qualified applicants. However, a sheriff can deny an application if they have reasonable grounds to believe the applicant poses a danger to themselves or others, a point that often raises concerns about subjective interpretation. Oregon CHLs are valid statewide, but it's crucial to remember that Oregon does not have reciprocity agreements with any other states. If you wish to carry concealed in Oregon, you must obtain an Oregon CHL, regardless of licenses held elsewhere. Open carry of firearms is generally permitted in Oregon without a permit, upholding a fundamental aspect of our Second Amendment rights. However, there are important exceptions to this general rule that every responsible gun owner must know. Local governments, including specific cities like Portland and Salem, can prohibit the open carry of loaded firearms in public places for those without a CHL. Additionally, all public buildings are off-limits for open carry if you do not possess a CHL, and it's illegal to operate an all-terrain vehicle or snowmobile with a loaded firearm. Now let's discuss suppressors, often misunderstood but perfectly legal tools for responsible firearm use. Suppressors, also known as silencers, are legal to own and use in Oregon, provided you comply with federal law. This involves navigating the National Firearms Act, or NFA, process, which includes federal paperwork, a background check, and a $200 tax to the ATF. There are no additional state-level restrictions on suppressors, allowing you to purchase them from a licensed Class 3 dealer. Next, we address magazine capacity, an area where Oregon has unfortunately imposed significant restrictions. As a result of Ballot Measure 114, it is now illegal to manufacture, import, possess, use, purchase, sell, or transfer large capacity magazines, defined as those holding more than 10 rounds of ammunition. However, there are crucial exceptions. The law does not require you to surrender or destroy magazines legally owned before the ban went into effect on December 8, 2022. Law enforcement and active duty military personnel are also exempt from these restrictions, highlighting the double standard often applied to citizens. If you legally own magazines capable of holding more than 10 rounds before the ban, their use is limited to your home or property, a licensed shooting range, or when taking them to a gunsmith. During transport, these magazines must be removed from the firearm and stored separately in a locked container, adding another layer of inconvenience for law-abiding citizens. Measure 114 also proposed a permit-to-purchase requirement for any firearm involving training, fingerprints, and a fee. However, this measure has faced numerous legal challenges, and its implementation has been delayed, offering a glimmer of hope for Second Amendment advocates. As of November 2025, the permit-to-purchase requirement and the magazine ban are not being enforced due to ongoing court decisions, with the Oregon Supreme Court scheduled to hear arguments soon. Other important considerations include the minimum age for firearm purchases, 21 for handguns and 18 for rifles or shotguns. Oregon mandates background checks for all gun purchases, including private sales, which must be conducted through a licensed firearms dealer. Responsible gun storage is also required, meaning firearms must be secured with a trigger lock, in a locked container, or in a dedicated gun room when not in use. Finally, always be aware that some cities and counties may have stricter local ordinances than the state, making it your personal responsibility to stay informed and compliant. Oregon's gun laws are complex and constantly evolving, so staying informed is your best defense against unintended legal issues. Thank you for joining us on The Right Slant. We hope this overview helps you navigate Oregon's firearm landscape with confidence. If you found this information valuable, please like this video, subscribe to our channel, and hit that notification bell to stay updated on all things conservative.